Whoa. Straight out the gate, we've got 7 years in prison on the table and a $500 fine. But here's the twist. Gracie's trying to get deferred adjudication, basically a legal lifeline that could keep her from having a permanent conviction. The stakes? Huge.
Calling 2022 CR 10214B, State of Texas versus Gracie Sagundo. Could I have parties announced for the record for the state?
Daniel S. Clark for the State of Texas.
Defense.
I'm here with you guys.
Are you Gracie Sagundo?
Yes, ma'am.
All right. According to the plea bargaining agreement, punishment is to be assessed at 7 years in the prison. There's a $500 fine. State is opposing your application for deferred adjudication. They're recommending community supervision, and there are items to be taken in consideration. Have both parties had a chance to review the PSI report?
Yes.
Any objections to the PSI report, state or defense?
Judge, so there are some errors on the PSI report that we want to bring to your attention.
Yes.
So it lists the offense date as, I believe, November 16th of 2021, when in reality the offense date on the indictment is October 16th of 2021.
All right.
And it lists that in the criminal history. There's an assault that within the criminal history that it makes it seem as if two separate offense dates.
Okay.
And then I think in the towards the back of the actual statement itself,
Notice how the defense is nitpicking the PSI report. Tiny errors about dates might sound boring, but in court, even small details can shape credibility. Think about it. If the record can't get basic facts right, how can you fully trust it?
Mr. Guido gave, there's a portion where it's talking about the current defendant and that he's charged with ag assault deadly weapon. Assault, yeah, it's the same offense. We just wanted to make sure you were.
All right. And the court is also in receipt of victim impact statement, and the court reviewed that without objections from the state or defense. Is that correct?
Yes, Your Honor. Yes, Your Honor.
And the court is also in receipt of letters that defense presented on behalf of the accused, and there were no objections to the court reading those letters. Is that correct, state defense?
No, yes.
All right, so the court has reviewed all of those documents.
All right. There also is a part of the agreement coming back today, which is the misdemeanor put on the same day with this alleged date. The consideration see county court board case 9701.
Yes, and the court does have that as a part of the plea bargain.
And Judge, just to kind of expand on it, I believe this an additional part of the agreement was that she was to take responsibility for what happens. Yeah, I was on it. Yes.
Yes. All right. So my understanding, the complainant in this case is Rebecca Martinez. All right, and is that Rebecca Martinez who's on the fourth court? All right. So that everybody can be aware, I do know Rebecca Martinez. She's never been to dinner at my house. I've never been to dinner at her house, but I do know her. We are colleagues, and when I see her, I say hello. She says hello to me. I may ask her about her day. She may ask me about my day. But I will tell you that my decision on this case is not going to be impacted by the fact that I know her. So if anyone has any objections to me hearing this, now is the time to say so. State?
No.
Okay.
Your Honor, I have all the confidence.
Pause here. The judge openly admits she knows Rebecca Martinez, the victim and a fellow judge. Conflict of interest? Maybe. But by law, as long as she can remain impartial and both sides agree, she can stay on the case. Would you be comfortable with that if you were the defendant?
All right. So are there any witnesses that anyone wishes to present? State?
State doesn't have any witnesses. The main thing that we wanted the court to hear was the statement from the complaint. Which the court has already made.
Defense, any witnesses?
Other than my opinion and our chief court consumer, since we've seen in this matter, I will be speaking this is going to say a couple of words. Mr. President, for the day. Just support the motion.
All right. Thank you.
We will not.
Right. So before I begin with your presentation, with regards to the case to be taken in consideration, if you could raise your right hand for me, please. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right. You can lower your hand, state your name for the record.
Thank you for doing it.
All right. And with regards to County Court Cause number 693-701, the state is taking that case into consideration, but to that case, how do you plead?
No contest.
Yes, I'm here. That's okay. So, in order for me to take that into consideration, she will have to accept full responsibility for it. So, a no contest plea, I can't accept that because I don't have any police reports in regards to that. So, she will have to enter a plea of guilty to it and accept responsibility for it. And then the state will tender dismissal to the court, and the court will sign that. I don't know if you want to discuss that with her.
We'll go ahead and proceed. We'll be figuring out.
All right. So the county court cause number 693-701. How do you plead to that? All right. And state, do you have the dismissal for the
Sure.
court in that cause number? All right. So the court then will hear argument. State, you're opposed to deferred adjudication?
Yes, Your Honor. The reason why the state is opposed is because of the nature of the offense, the actual underlying facts. There was an assault that occurred where the resulting assault it created a lot of issues for the complainant. She was severely injured. Her life was severely impacted from that day forward, and she still feels an impact to this day. It's something that was senseless. It didn't need to happen in the first place. So that's why the state is opposing deferred adjudication.
Defense?
Here comes the drama. The prosecutor paints this as a senseless assault with life-altering injuries. The defense? They spin it as one terrible night that shouldn't define Gracie forever. Classic courtroom clash. Punishment versus second chances.
Your Honor, we're here because one incident can't define a person for the rest of their life. And this is very serious, and no doubt we take that very serious. This is a felony charge. It's a felony charge that is very significant penalty. Gracie Sagundo, I think, has demonstrated respect not only to others but to life and to animals in her work and her career and care of pets. Rarely do I have an opportunity to where a client can provide 32 letters of reference about how wonderful she is caring for others. And that is the life that she defines herself with. We just feel like this should not define her as a felon for the rest of her life when she has 4 children as a single mother. We know that life is difficult and it's very, very, very hard. And she's having to raise 4 children on her own, just 15, 14, 12, and 10. As a single mother, she has to be involved in school activities, support the activities that they a felon cannot be associated with children, be around them in school activities. So drastically impairs her ability to be a mother to her children. So she's really fighting to be able to continue to provide the love and support of 4 children that need their mother so that they can become better than her and have a future. She lives in Houston. She uses a home. She's lived in that home for 3 years. She has good family support. As I've said, her mother and father are present. She has a high school diploma. She has been employed during this whole time. This case is 2 years old. 2 years. This happened. It's 2 years that she has been experiencing this, and she has complied with everything this court has asked. She's appeared in court. She's traveled to Houston, San Antonio. She's fully cooperated. She has weighed all of her decisions, sought not to seek a trial, but to put the decision on deciding on it. And she made that decision because she felt that was in her best interest. She does receive some child support. She is willing to do everything and anything that it takes to give her this opportunity. I explained to her that deferred adjudication is a double-edged sword. You may think that, okay, you're not going to be subject to a conviction, But in actuality, you are subject to all the conditions of the treatment for 7 years. We're asking you, Judge, to give her that chance, to give her the opportunity to prove to you that this one instance does not define her life, who she is, or how she is as a mother, or how she works. This case is very regrettable, and it should have been a day of celebration. It was after a football game, and she was acting in defense of another. She doesn't know the victim in this case. She doesn't know the judge. She never knew who she was. And I sincerely believe that just because she's a judge doesn't mean that this case should be treated any different than any other case of any other person who comes to this court gets justice. Because she should get an opportunity to do it. She's willing to do the urine analysis. She's willing to state no contact. She's had no issues in the last 2 years with plaintiff in this case. She's willing to take anger management classes. She's willing to do community service. She's willing to do what it takes to give her the chance. And she has proven, other than this one incident that happened in a flash, wasn't premeditated, it wasn't thought of, it was just something in a reaction in defense of someone that she was with. And for that reason, that she should be given an opportunity to earn the right to be able not to be a convicted felon. The amount of restitution in this case agreed to that was presented before the court was $2,416.29. We fully agree on to pay that. People work hard every day to do that. But in this working community in Houston and San Antonio, mothers every day have challenges. We regret that this happened, and we know that she sincerely, with nothing personal against Ms. Martinez or her husband, she wants to do what's right, but she also wants a chance, Judge. And I'm asking you, all the fiber of my body, to give her that chance. And I will make sure and work with her that she will comply with every condition, and she will never be back here for you regarding any violation of any conditions.
No. All right. Well, just so you know, in this court, I see everybody as a human being. I don't see them as their titles. So, for me, defendants are not defendants. They're human beings who are accused of a crime. The fact that Rebecca Martinez is a judge, that doesn't mean that I'm putting weight on the fact that she's a judge. If she were the president of the United States, she were here as a complainant, I wouldn't put weight on the fact that she's the president of the United States. I'm just dealing with the facts. And my job is to look at everything objectively and not outside noise, not what people's occupations are. You understand? So I always reread everything and reread police reports and the PSI reports, and I've read the letters. I do not understand how the fact that an elevator has a limited capacity, how we go from people saying the elevator is full, you cannot be in an elevator, to it's a brawl.
And now the judge cuts straight to the heart of it. How does an elevator argument turn into a full-blown brawl? Great question. This is where everyday tension, too many people, too much alcohol, spirals into a felony assault. Real-life proof that split-second reactions can rewrite your entire future.
So explain that to me. I mean, there has to be some sort of thought process. For example, if there's an elevator, I think everybody knows there's a weight capacity on the elevator. Me personally, when I see there are too many people on the elevator, I don't get on. But obviously what we are here now for is there's an elevator. According to everything that I've read, the elevator was at capacity. And there were already some people on there. I don't understand how an elevator is at capacity. People need to get off or more people can't come on. How that ends up in a fight.
I couldn't tell you how it happened. You know, somebody in my party was getting into it. Somebody hit me, and I just reacted. And unfortunately, I feel bad. I should never have done that. Shouldn't have cut to that. And it just happened really quick.
I know things happen quickly, but the police report I'm reading, it doesn't say that somebody in your party got in an altercation and you got hit, and so therefore you got into a fight. What your counsel is telling me is that somebody in your party, I guess, was in a fight, and then you decided to get involved in that fight.
You know, I went to go and try and pull my my friend away, and then like, I don't know, it was just a bunch of people. Maybe I mean, I just reacted.
Your Honor, if I could clarify, I think the fact is this is a COVID era situation in the elevator. These elevators can accommodate 18, 20 people. They're living in the facility. And as people went into the elevator, the policy and procedures of the elevator operator is not allowing, and then once they were asked in the elevator, they were asked, there was too many in the elevator, and then people had to decide who was getting off, and they asked who she was with, another man and another person to get off the elevator. That person said, I want to talk to your supervisor. That individual involved with the victim's husband that spilled out of the elevator onto the floor. She gave the assistance to that man, and that's when she was hit, and that's when she struck. That's in one of the reports here that was provided to you in the PSI. She did not go in there to fight. She didn't go in there to look for someone to fight. She was trying to get someone off her rent. And the process of that was struck, and she struck, and she instructions. And so, regrettable, Judge. There's no doubt about that. And this incident happened in a matter of seconds. And that's what we're here 2 years later doing that. In addition to that, Judge, there is a civil suit in this case. Well, parties in this case are seeking $1 million in damages against my client. And so the case will not end today. It will continue in a civil matter in the lower court, where she will have to defend herself in a civil cause of action, money damages.
So, Judge, just to clarify from the state, and I would disagree with the characterization of how the incident started. The party was already on the elevator. The plaintiff's party was already on the elevator. They were asked to not enter the elevator. They weren't kicked off the elevator. They were asked not to. And that's what started.
I also have a copy of the lawsuit that was filed this week before the Senate says $16 million damages, a civil lawsuit, right? You want to see the judge? It's probably correct.
I would object just go this.
The lawsuit's involved in the city court. That's a copy from the courthouse.
All right. Unless there are some facts that are listed in the lawsuit.
The whole case, John. Exactly what you're talking about is pled in the civil suit.
I mean, if that document has facts that somebody has, well, alleged facts that somebody has presented, that's a different rendition from what's in here, then the court will.
It doesn't.
All right. So,
I'll let you know that it's a civil suit.
all right, then the objection will be sustained. All right. Anything else from either side?
Yeah.
All right. I've read your letters that were presented, and it appears that, other than this one incident, you're a great person. But sometimes sentencing, well, not sometimes, always sentencing has to do with punishment, rehabilitation, and basically whether or not someone should go to prison or not go to prison. These are all things I have to think about. You understand? And so I have to weigh certain things. And the things that I'm weighing are the fact that there were people in the elevator and you were asked not to get on the elevator. Is that correct or is that not correct?
On the elevator.
Honor, the elevator door is open, and you into the elevator, and then asking two men in the elevator off to ask people voluntarily get off.
All right, so there were already people on the elevator. Then you got on the elevator and you were asked to get out? All right. Then you were asked to leave.
They sort of get off.
All right, so why didn't you just get off the elevator? That's what I don't understand.
She didn't decide that. It was the person she's with. With the defendant in the case. In another court.
So my question is though, if there are too many people on the elevator, and let's say you get on the elevator, it's a group of you, the elevator is already filled. I'm assuming, and correct me if I'm wrong, people were on the elevator, they had not met maybe their 7-person capacity. And then you and your group come on, and because of the number in your group, they've exceeded their 7-person capacity. Then they're saying, you all need to get off the elevator and wait. Why not just get off the elevator? That's what I don't understand. Even if you're with somebody in your party who says, I'm not getting off the elevator, why didn't you just get off and I'll wait for the next elevator? I'll take the stairs. I don't understand.
We've already gotten off 2, 4, so you've been waiting, so we want to be able to get out.
And was alcohol involved? Or people just don't want to take the stairs? State, does anybody want to? I know the complainants are here. Do they want to say anything to the court?
No.
Okay.
Oh, Your Honor, may I have one moment?
Yes.
Your Honor, I'm going to call for this question.
Okay.
He's not why would we
I mean, we'll see what he has to say. I don't know if he's a relevant witness or not, but if he were present at the scene.
I would think that the person involved is the one who's this case is the one that would need to trust him. He has his day in court, not spoken before the court. We'll see why he is in this case, sentencing.
All right. You can call your witness.
State call David Martinez.
All right.
Okay.
You're welcome. If you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand if you'll state your name for the record.
David Martinez.
All right, state.
Mr. Martinez, from your memory, what occurred on that day?
On that day, we were in line to get into the elevator. The capacity of the elevator, of course, as I mentioned, was 15. But because the COVID era, there was an elevator attendant there, specifically 8. He allowed in with 30 couples and 2 children, which were a total of 8. As we walked, we were already in the elevator. They decided to come in behind us. The elevator attendant told them to step out. It's full. They have been intoxicated. Her friend.
Objection, speculation.
Overruled. No. Yeah. This thing. Where you cannot address the attorneys. Once the objection is raised and stop speaking, I'll make a ruling on the objection, and then I'll let you know if you can continue or not if you have a question about that. That objection will be overruled.
He came in, stood at the door, prevented the door from closing.
Objection, Your Honor. Is that's the time. He is.
Which year are you speaking about?
Her partner, there was 2 gentlemen, which was the initial one that started arguing with us, and her partner that she was mentioning that walked in. They were in the elevator when they decided to block the door from closing. Can't recall the individual's name, but it was a younger gentleman that was with her. He proceeded to argue with the elevator attendant about, letting them in or not, but it was BS that they cannot be left in because there was a lot of room. And she told him to have to leave. He continued to argue with her, and he said he wanted to talk to her supervisor. And she says that that's the case. She shut off the elevator, and that's when the words were back and forth. He continued berating us. She was cussing like a sailor, as well as the other ones. We kept quiet, and they started again arguing with us. We stayed in there. The kids were getting terrified with what was going on. They started crying, and it continued with their vulgar language. And I just told them one time, that's it. With you, the gentleman that was with him got upset. He literally from the outside ran into the elevator, just all over, and assaulted all of us in there. I grabbed him and pushed him out. It was not the individual that she says was in there. It was the other individual that was with him that probably hosted them to the game. He and I went outside. And after that,
From there, sir, is that where the
correct.
counsel is judge?
Any questions?
So I think I'll just start right from leaving the elevator. So by the time that you set foot on the elevator in the middle of the altercation, right? Yes, while I was on the ground. How much were you able to perceive about what was happening around you while you were in the middle of the violation? I was in the ground.
Yeah, all right.
So my question was, how much were you able to perceive about what was going on around you during the middle of the school? I was not able to see when I was in the ground what was taking place. We can agree that the incident in question faces a criminal case grade is something that happened during the middle of the school, right? While I was on the ground, and that were partially saw my wife on the ground with a bloody nose. She was in a daze, and I asked what happened, and I told her that she got hit. She said, yeah, multiple times. And I said, well, why didn't you finish up? She said, couldn't, because I was being held back. Can you say for working out in this case? Amy was acting the other one she got involved in.
I'm gonna object her relevance.
All right, that'll be overruled. You can answer the question if you know.
I can't see that. Yeah, I guess. Oh, and I understand Mr. Martinez want justice on behalf of the injuries to your wife. I just want to make sure that we're also seeking justice because the security of the game based on how the goals that there's no there was only two other parties involved. The party, the individual, and the other. There was only her left with her. There was nobody else around. There's people watching. He was getting involved, but they're the only ones actively physically good at that. We started this conversation with what happening in the elevator. Prior to the altercation in the elevator, did you say that anyway, Sagundo was the instigator and was trying to stop this situation? I have nothing about it.
All right, any other questions?
Nothing from the state judge.
All right, thank you. All right, any other witnesses?
No, Your Honor.
All right. Court will hear final argument, if there is any.
Your Honor, I think it's clear that Mr. Sagundo did not start this incident. Her actions occurred outside the elevator as a result of offending another person. She doesn't deny that she struck Ms. Martinez. This was a situation where she was struck as well. And we believe that one incident wasn't premeditated, it wasn't started or caused by her. It reminds me of a penalty, and another individual comes to their aid, and then another flag comes up for a penalty. Both penalties. Most cases in sports, those are offsetting. And I think in this case, looking at the situation, looking at history since that day, that I think it would be fair to give this single mother a chance to continue her life and being a mother and working at her employment. So not to have this crash down on her with her children, with her workplace. We can't promise that she will keep her job upon this conviction. We cannot promise that she can be able to parent her children and be the primary caretaker of her children as a result of this conviction. But we can promise that if she is given a chance, she will do everything in her power to remain on probation for 7 years, to do what's right, so not considered a felon in a situation that she wished never had happened. There's no ill will here. There is no desire on her part to do anything but move on with her life and pay what's owed, the $2,500, and do what it takes to win your trust. So we're asking Judge that deferred adjudication be given to this woman so that she can continue to do her life and do good for her children and for her work and her community.
State, any final arguments?
Your Honor,
The concern from the state here is, again, facts of the case. It's that, yes, she wasn't the instigator. She chose to take it to this level. It was her choice to take this out on the complainant. It was her choice to get involved against the complainant, not show restraint. It's the issue that this all started over something very trivial, that if just a little bit of patience, this would have all passed over. That moment that she decided to act how she did has affected the complainant from that day until today. And it's going to affect her past. That's why the state is asking for probation on this case and to not graduate.
All right. So what is the amount of restitution and who is the restitution to?
It's to Rebecca Martinez, and
$2,416.21.
Wait, 2,400?
$16.29.
And also in the plea bargain agreement, it says restitution to
Jeanette Rojas.
yes.
Your Honor, so we haven't gotten any medical or relief from there. We had asked restitution to determine on that.
All right. So with regards to the restitution to Jeanette Riojas, if there's a restitution amount that's submitted to the court and you all have objections to it, we can have a restitution hearing.
Thank you.
And I'll just write in that there's to be a restitution hearing as it relates to Jeanette Riojas. And I'm assuming she's going to want to transfer to Houston?
Yes, Your Honor.
And what?
Harris County.
All right. Ms. Sagundo, I've listened to all arguments. I want you to know I paid very close attention to the arguments that were presented, to the witnesses, and to all of the documents that the court reviewed. I realize that sometimes when things happen, it's just a Snapchat or somebody's life, right? It doesn't mean the person is a horrible person, and I'm sure if people could go back and change things. Sometimes people are serious when they say, if I could go back and change things, I would. Maybe I never would have went to the game. I would have just let the elevator went. I would have taken the stairs. I understand that. But we can't turn back the hands of time, right? And the problem in this case, and one of the things that I'm looking at, is the fact that the complainant has serious injury. It has nothing, my consideration on whether they're a judge or not, that's not playing any factor in my decision. If she did not have that occupation, let's just say she worked at the HEB, for example, then based upon her injuries, she wouldn't be able to work at the HEB. She wouldn't be able to stock. She wouldn't be able to stand and be a cashier. I don't know what they would have her doing at the HEB. You understand? So her injuries are very serious injuries. And I've read the report that was given to me about her injuries, and I've read the PSI report, and I've read the police reports again in this case, because I always like to do things. So I understand that you're very sorry for what happened. Sometimes, yeah, it's great that you're sorry. It's great that you've internalized things, but there is still some punishment associated with it. And I understand that sometimes when people have felony convictions, they say, well, now I can't do this, I can't do that, I can't do this. But then when you look at the complainant has some lifelong issues. And that's the report that I was given and that your attorney has read. The injuries that she suffered are not going away. And from the report I read, it sounds like they're never going away. She's always going to have those injuries. And I think you know that when people have broken bones, there's a change in the weather, their bones ache. I have it with my fingers because at one point in time, all my fingers were broken on my left hand. So I know when the weather's changing, it's a little bit painful, not unbearably painful, but it does. So those are a whole host of things that happens when somebody suffers the injuries that she suffered. I understand, as I said, that you're sympathetic, and I believe that you're sympathetic, and if you could do things over, you will. But I am where I am right now, okay? All right, this is what the court is going to do. Court will find you guilty, sentence you to 7 years in the prison, suspend it and probate it for 5 years. There's a $500 fine that will be probated. There's a transfer to Houston, Texas, Harris County. Taking consideration County Court Cause number 693701, there's to be restitution of $2,416.29 to Rebecca Martinez. There's to be no contact with Rebecca Martinez or Jeanette Riojas. Proof of employment within 45 days. There's to be no employment as a home health care provider with minors. 100 hours of community service restitution. That'll be waived once you complete parenting classes. There's to be regular reporting by Zoom or in person, regular UAs, and restitution hearing as it relates to Jeanette Rioja. I don't see this as an anger management situation. I see this as an aberration. I think she doesn't need anger management classes. So is there anyone going to object to me not giving her anger management classes?
See one.
All right. Probation, is there anything else she needs?
No, Your Honor.
Is there anything else you need from the court to be successful? All right. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. So, what I've learned in my time on the planet, it's just best when somebody says, oh, you can't do that, and you want to argue about it, another day to argue about it. You understand? All right, good luck to you.